So we have here this evening Lela Pittenger, who is one of our fellow activists. I've asked her to join me here and to ask any questions she might have or make any comments, and so we can have a little bit of back and forth here.
Okay, so my first question would be, how do you respond to the people who would tell you or might say, well, I thought this is what the judiciary was for. It was their job to decide when legislation was unconstitutional. Isn't that why we have a Supreme Court? How do you respond to that?
Well, that is what they're supposed to do. Unfortunately, the judiciary is very often part of the problem as it has emerged. Because while it was the judiciary was supposed to be an independent branch that could stand athwart efforts by the other two branches to violate the Constitution, the problem is they're not strong enough to do that. Now, they're strong enough to do a lot of things that we can object to. A lot of the problems that, as I said, we've seen are actually originate among the judges. But they are not in general willing to stand against Congress for very much. Once in a while they will, as they recently did in the case of Citizens United versus the Federal Election Commission. Now, that was a 5-4 decision. A lot of us libertarians think it was a great decision. A lot of Democrats think it was a terrible decision. But regardless of what side you come down on it, it was very unusual. Now, the Supreme Court does not overturn a major piece of congressional legislation like that for many years. They're very reluctant to do so. They get a lot of pressure when they do so. There's also the problem that Congress introduces about 20,000 bills a year. They pass about 2,000 of them wind up becoming part of legislation. Among those, there are perhaps 20,000 independent provisions, each of which could be the basis for a cause of action. A typical case, to carry it all the way to the Supreme Court, will generally cost about $1 million. Very few people can afford to do that. If everybody who could afford, if everybody came up with the money to do it, the courts couldn't handle the load. It would far exceed their ability to hear all the cases. The Supreme Court gets about 8,000 cases submitted to it every year. Of that number, it's only able to hear about 80. Justice Roberts, when he was under consideration for Chief Justice, said that he hoped to be able to increase the productivity of the court. They used to be able to hear as many as 150 cases a year. That still isn't very many. So the courts, particularly the appeals courts, are a bottleneck. They simply cannot, even if they were disposed to do so, hear all of the cases that should be brought before them. Congress knows that. They have developed the attitude, well, we don't need to worry about whether it's constitutional. We'll just pass it and let the courts deal with it. Knowing full well that the courts cannot possibly deal with all of the unconstitutional legislation. There's just too much of it. So that leaves us with the problem of finding other remedies, other ways of opposing unconstitutional legislation. Now, the ballot box is of course one of them, but it's very difficult to get voters excited or interested over particular cases there are just too many of them. Most people don't understand them well enough to make it a political issue. I've been one who has been trying ever since I ran for Congress in 1974 to make constitutional compliance a leading issue in a political campaign. And until Ron Paul this past year, it was almost unheard of for constitutional issues to be leading issues in political campaigns for the presidency, and almost never for Congress. It's unclear whether this is really the result of a lack of interest on the part of voters, or whether it is simply an effort on the part of both incumbents and challengers to avoid issues that they think their voters won't understand. But regardless of the reason, we have lacked an effective mechanism to overcome this flood of unconstitutional legislation. And of course, let's not forget all the regulations and of course the court decisions themselves. When the Supreme Court decided in Kelo versus the City of Hartford, which is in Connecticut, that it would not overturn the effort of the City of Hartford to take property under its eminent domain proceeding for, not for public use, but for private development, that raised a firestorm. But that's very unusual. And it even led to an amendment here in Texas, but it was a very poorly crafted amendment. Yes, it did get adopted, but that one really needs to be rewritten. And the fact that it would be so poorly written is a problem in itself. We need to have a way of addressing these constitutional issues more effectively, and the nullification efforts that I've described could be another tool, important tool, for doing that. One in particular that would educate the voters in a way that nothing else seems to do.
Okay, so my next question is, you talked about this panel not being just common men, but actually people who have a strong constitutional background and study and understanding. Let me ask you, recently with the State Board of Education and who reviews their materials, a lot of people came to understand that the reviewers, that list had maybe been stacked by certain special interest groups. How do you make sure that this group of people who might be on this board would truly be of many backgrounds, many interests, and not somehow stacked with nominees from special interest groups who have a particular desire for the movement of and swaying of this board? Is that a fair question?
Yeah, well, one of the things we try to do there is to select them at random from a much larger pool.
Mm-hmm.
Now, of course, the pool could be stacked, but if the idea is that a pool of constitutional scholars would be those who have written something of a scholarly nature, either a book, a law review article, a scholarly journal article, something of that sort. So they've demonstrated their professional ability to research and write in this field. Now, of course, the question naturally arises, well, most of the people in academia are liberals.
Yes.
So what's to prevent this commission from being stacked with liberals who will
Reinterpret the Constitution.
who will accept unconstitutional federal actions as okay, just fine with them? Well, I think here in Texas at least, there are so many people with some constitutional credentials who are libertarian or conservative that we will probably not get that kind of mixture.